this whole conference was initiated in order to think about issues in the future of health law, and there has been a little more discussion of it, as I think Wendy Parmet mentioned this morning, perhaps a midlife crisis, perhaps angst about what's going on. So I thought I would take 2 minutes to do a quick sort of history of the development of health law. This is the first health law professor landing with the Mayflower, and talk a little bit about the direction that I think things may be going, and perhaps a small summary and critique of ideas of conceptualizing health law and a proposal of my own that needs perhaps some comment from those of you who are here. It shouldn't surprise most of you to recall that when health law, as we know it now, began with people like Bill Curran, and back in, say, the 50s and 1960, it was largely presented as part of medicine, medical. It was a medical subject, and in forensic pathology, psychiatry, how things could be used in the courtroom, not a bad follow-on to our last panel. So that it really began as a field of medicine, and back in even 1804, James Stringham defined medical jurisprudence as that science which applies the principles and practice of the different branches of medicine to the elucidation of doubtful questions in courts of justice. And later, in 1942, Alan Moritz defined legal medicine, which was the next name, as the application of medicine to the needs of justice. Notice which is an adjective and which is a verb, that medicine was the subject in these things, and it was a study of medicine and how it could be applied to to solve legal questions. But that changed, and it became more a topic of law because, as Bill Curran then said, what was actually being taught in these courses was law. We were teaching physicians what the law was and what kinds of information they should bring in order to help decide questions about insanity, about, it was the early version of CSI, right? What kinds of evidence could be brought to bear on determinations of responsibility in homicide, for example, in paternity suits, et cetera. But it's quickly shifted into a field of law, and the shift then you can see, again, with another shift in the noun and the verb, because law is now the topic and health is the adjective. So the subject is law, as it generally was, and has been for a fairly long time, and has been sort of morphing into lots of different topics. We've talked about the different legal domains. We've gone from the patient in the sole relationship between physician and patient to the development of biotechnology, to the rise in costs, with one of my favorite cartoons, the physician standing on the corner who says, we'll work for hundreds of thousands of dollars, to genetics, to corporate regulation, and to international concerns, including terrorism and the blood pressure cuff that results in the terrorism levels in the country. And the bodies of law in this field expand exponentially as the system, as the healthcare field and the concept of health itself expanded. This is a list that I constructed, but I realized listening to John Robertson this morning that I did not include property law. I included intellectual property, but not property law. And I put international law last on the list only because I think it is the most recently recognized. Now, how do you look at a field that draws upon all of these legal domains as anything more than an applied field? Because that's what we do, right? We define the field by virtue of what it is, what it applies to, matters affecting health. And so the debate really is it anything more than an applied field? Is it simply the sum of bodies of law as applied to medical care and other health endeavors? Clark Cavenhurst complained, of course, that you really couldn't call it a legal domain in the same sense of typical domains like contracts or constitutional law because there was no even single statutory basis that you might argue for environmental law, for example, or securities law, for example, or a doctrinal domain like contracts or torts, although there are arguments about the coherence and boundaries of those and blending as well. So is it simply the sum of all the bodies of law that are applied to medical care or other health endeavors? And some would only say healthcare, and others would say a broader sphere of health-related concerns. Or is it simply the sum of the laws governing 16% of the GDP, which is another way to look at it, and part of the reason that lawyers care about it, because they're practicing it, because their clients are in the field, one kind or another, in the pharmaceutical industry, in the hospital field, in anything all over the set? Or is there something special about it that it's not simply applying the domains of law that you're familiar with and they happen to apply in this area, but there's nothing particularly different about the area that requires that they be adapted in any way? Is there, in fact, a need to adapt the principles to reflect values in the field, like professionalism, as was much of medical care in the very early days, with medicine being ostensibly a self-regulated profession and deference going to the standard of care adopted by physicians, deference accorded to physicians with respect to what, if any, information they disclose to patients, or ethics, that as there was a great deal of burgeoning concern about ethics with the movement with respect to the rights of research subjects and the like. Does the subject to which we apply the law have sufficient special value that it requires adapting legal principles to make special principles in the field of law, as has happened indeed? Or do we just simply call it, it's an eclectic field that draws from everything and puts them all together? Well, I was looking at ways in which health law has been organized in textbooks and in past discussions of the topic, and it's astonishing to me that it seemed to always fall into rules of 4. Every time you look at the subject matter is organized into 4 categories. I don't know if there's any meaning to that, but it's a fairly common concept. So early textbooks like Curran's did basic things like medical liability, bioethics, financing, and corporate regulation. Those were the 4. Then you have Barry's book, which focuses on what I think are goals of healthcare system, and quality of care, autonomy, access, and cost. These are really important ways of looking at the healthcare field. I then dug up something that I had done with a task force back in 1985. Talk about something old. Do you remember this? You published it, exactly. You published it in the Detroit Law Journal. And lo and behold, 4 categories. There was actually a matrix, but there was a matrix. I'm a big fan of matrices, in which we looked at the ways in which law applied at different structural levels of social institutions: international, governmental, institutional, and individual. But, as a good footnote should say, take a look at George Annis's piece in which he says, talking about the field of law and medicine, as it was often called, is it anything more than law and a banana? And Judge Easterbrook picked up on this theory about 6-7 years later and said, gee, any law and course is largely incoherent. The fact that it could say, for example, he said, what about law and the horse? The fact that there are lots of cases about horses does not mean that horses are a legal field. The fact that there are lots of cases about law and health does not necessarily mean that there is a legal field. But meanwhile, we search for that. We search for a theory of health law, and the question is, should there be a theory of health law? Is a comprehensive theory possible? Can we go beyond simply describing the kinds of law that go into the relevant practice of the field. And does anyone really care? Except appointments and promotions committees at law schools. Probably not. Nonetheless, it's interesting. And so there seems to be an effort to try and make sense of this cacophony of domains and how they are applied. This is a little bit of a cheat. This is actually a goof on the Medicare Part D plan and what it probably looks like to the consumers. But it also looks a bit like us, fumbling around among legal domains, trying to patch them together in ways that would make sense out of the kinds of laws and principles that we have in the field of health law. Well, we can think about shifting the paradigm because we have graduated beyond the physician-patient relationship and bioethical concerns and simple liability into a far more complex world. And I have argued, and still would submit, that the health law field goes well beyond the field of medical care, that indeed that we would be missing the boat if we did not take into account the fact that the determinants of health are far beyond medical care, which may be last on the list, and could begin with income and wealth, as Kevin mentioned this morning, the concept of wealth and inequality being a major contributor to not only whether one gets access to care, but the basic condition of health that one has in the first place, housing and occupation, certainly the environment, which we find convenient to carve out because we know somebody else is already teaching that. Behavioral concerns that Leonard touched on that are increasingly important today, although that may have more to do with the cost of care than with concern for health, and genetics. So all of these, if we were to be honest about what matters to health and what laws are relevant to health, certainly are relevant here. So I have found it useful to think about the field conceptually in terms of the international human right to health, based on the Universal Declaration of Human Rights. And I will explain why this is not quite as airy-fairy as it sounds. The basic concept of the Universal Declaration of Human Rights is that everyone has a right to a standard of living adequate for the health of himself and his family, including food, clothes, housing, and medical care, and necessary and social services. You see, it goes, and this at least recognizes that health is not necessarily a value or a condition that can go by itself. To elaborate a bit on the rights from the international perspective, Article 12 of the International Covenant on Economic, Social, and Cultural Rights describes the right to the highest attainable standard of physical and mental health. Note, this is not the same as the WHO definition. This is the highest attainable, which of course encompasses resource constraints in achieving that. But notice also that equivalent rights deal with equality, the right to work, fair wages, decent standard of living, and the like. The Committee on Economic, Social, and Cultural Rights, of course, has developed an explanation of the right to health in Article 12. And I think this is an important conceptual approach to thinking about what health means from the perspective of law. And that is specifically that the right to health contains both freedoms and entitlements. Not that you have a right to be healthy, because we're not guaranteeing that, that's possible, but it emphasizes that there are both freedoms, that is what we think of as human rights, and entitlements, that is social obligations on the part of the state to make it possible for people to be healthy. And I think of it in these terms, that they are two pillars of the human right to health. One is individual justice, the sort of rights and protections of individuals, which could, personal freedoms, and the other you could call social justice, that is those social constructs that preserve the environment, the community, the healthcare system that make it possible, and all kinds of environmental and workplace controls. So in thinking about this, you could look at the approach that comment 14 describes about the international right to health. And that is that the state's obligations are to respect, protect, and fulfill the right to health. Well, what does that mean? Well, when you think about what it means to respect personal freedoms. The state has to respect personal freedoms, protect individuals' health from interference by external forces and third parties, and fulfill the right to health by providing services insofar as is feasible on the part of the state. And that struck me as being very like the kinds of laws that we put together. And so I apologize for the length of this, but let me explain it for just 1 minute. If you take a look at the left-hand column and think about the human right to health, that the obligation to respect personal freedoms has parallels in health laws, in laws in general. And in the human right to health construct, respecting personal freedoms means non-interference with individual human rights. And they include things like protecting liberty, protecting privacy, enforcing non-discrimination, particularly in access to care and the like. And lo and behold, we see parallels in laws governing individual rights in the healthcare field. Laws like informed consent and choice of whether to deal with research, protection of privacy, confidentiality, anti-discrimination laws and guaranteeing access to care. There are these basic fundamental protections of individual human rights within that sphere. In the second category of protect, the state's obligation to protect a person from harm or interference by external sources or third parties, these are really characterized internationally as ensuring that there is safety and reasonable quality. So you see the parallels in the kinds of laws that we have concerning the protection of the environment, safety standards for dangerous products, for drugs, for medical devices, standards for workplace safety, environmental standards, even marketing standards and requirements, fair disclosure laws, consumer disclosure laws, marketing limitations, required warnings, regulatory systems such as antitrust and the anti-fraud and abuse kinds of guidelines. These are the kinds of structures that protect individuals from having their health harmed by third parties or by the environment that the state can regulate. And frankly, this is where the largest set of laws operate. They're mostly statutory and administrative, but certainly that's the large sphere. We tend to spend a lot of our time, or used to, in the first category, but even criminal laws, prohibitions against prescribing drugs that have not been approved by the FDA, prohibitions against controlled substances, et cetera, fall within the protection of health against harm by third parties. And finally, the more proactive, in the sense of having some kind of economic heft to it, is the obligation to fulfill health needs, which from the international perspective means putting together the legislation, the administrative structures, budget measures that can ensure that there are both preventive and curative services available, ways to protect the environment, ways to promote education and research to improve health overall. And you can see the parallels in the kinds of social services systems that we have in this country, things like health benefits, everything from Medicare and Medicaid, the establishment of the Veterans Health Administration, regulations of insurance to provide care, direct clinical services, often at the state or local level, substance abuse clinics, family planning services that are given to people, public and professional education, information educational programs, and the funding of research from the NIH and elsewhere. So this seemed to me to be a useful categorization of laws that begin to make some sense. It's useful in the sense that it allows you, well, I think it's helpful to remember that if you are concerned about an issue of health, if you think of the human rights and health framework, you may be reminded that there is law in a place that you have not thought to look. In other words, it reminds you that there are all kinds of laws that may be relevant to health, and that you should perhaps look at instead of getting stuck in one narrow sphere. But is it a theory? Not yet. It does, I think, help to describe the application and adaptation of relevant law to protect health within the constraints of human rights. In other words, it's useful for identifying laws that affect health. And it can be useful in evaluating the capacity of particular laws to improve health without violating or impairing human rights. And I think that's important because we may need a theory to tell us which, for example, which of these domains in law are relevant or effective to answer a particular question. What we don't have from this, what we have here is the categorization and the general purpose they serve. What we don't have from this is which one you use in which circumstance. And that, I think, tends to require characterizing the nature of human conditions, whether it's bodies or tissues or genes or the nature of health itself. And that may require a larger moral theory. Now, here's where we've often run into problems, because in analyzing specific questions within any domain, the arguments from theory often devolve into arguments in ideology. So you have a market-based answer to something as opposed to a government-based answer. And that is not necessarily resolved here because the human right to health does not dictate either market or government control of a problem. It simply requires that government provide or protect. It doesn't dictate the form in which that occurs. So there is some vulnerability to ideological conflict in playing this out. But nonetheless, I think it may be helpful if, generally speaking, we look at the kinds of laws that are under the protection concept, standards of safety, health standards, marketing standards, the regulatory system in effect, and also the Category 3 fulfill category, the providing services, research funding, that sort of thing, as within the concept of respecting rights, so that you can perhaps, in an iterative fashion, identify the concept of the use of law that would best protect health within the constraints of human rights, that is, without interfering substantially with human rights. And there will be play in that system. And these categories are not perfect. There's some overlap, there's some slippage, but it may give us a conception of how to think about the interplay between legal domains and health. And I think that's particularly valuable because I still think that health law is a question of law and not a question of how law serves health. It's a question of how we use law in health fields, but without forgetting the fundamental concerns of human rights that perhaps began the field and that can create and that can provide some moral theory to it. So I offer that as one way to conceptualize the issue, because I think the social determinants of health and global reach are increasingly important, and that we recognize that health law entails both protecting human freedoms and developing social institutions that make good health possible, that this kind of framework may help identify, integrate, and evaluate the kinds of individual rights and social obligations that can both protect liberty and health. And it has the advantage of allowing us to talk across jurisdictions with our colleagues in other countries that are not so jurisdictionally bound. So that is all. Thank you.
Thank you. This continues Wendy's presentation and looks at not just the field of health and human rights, health law and human rights, but health law, bioethics, and human rights, which is not coincidentally, the name of our department. And the question is, or one question, the question I'm going to address is, we all know we use metaphors for all different reasons, but mostly we use metaphors to help us understand something, and metaphors can be a mirror to help us explain something with something else. They can also be, as other people have pointed out recently, magicians, help us transform something into something we want it to be, or even mutineers can undermine a field. Well, I'm going to try to use the metaphors more like magicians, but we're going to go through the metaphors that have been used in this field, not the horse metaphor, that's not a good metaphor, but other metaphors. And I'm going to begin with reality and then move to metaphors. At Nuremberg, bioethics, which hadn't been discovered yet, but actually was born at Nuremberg, and international human rights law, which had just been discovered a couple months before in the big trial at Nuremberg, came together and were used together and have been disassociated for a while, but then became associated. Let me get rid of that. Yeah, it didn't though. Go away. Okay, thank you. All this following World War II, which was the cataclysmic event that changed the world for all kinds of reasons, but also ushered in as a response an era of international human rights law and bioethics. And at the doctor's trial, the first major trial after the International Military Tribunal, the United States tried the Nazi doctors for war crimes and crimes against humanity. And the doctors and lawyers, that's Dr. Leo Alexander there in the slide on the bottom, worked together to try the Nazi doctors and to set the standards by which medicine in research would be judged. Leo Alexander was one of the individuals who was involved here at BU 50 years ago as well. Actually, he was involved 60 years ago. His papers are at Muger, right next door to us. And his colleague, Andrew Ivy, the other physician at Nuremberg, was invited here to discuss this book that I mentioned before, Irving Latimer's book, Clinical Investigations in Medicine, in 1964. So, but these guys were together in Nuremberg in 1947 and helped usher in, as I say, the field of bioethics, which is the ethical standards for physicians, especially in the area of research, and the application of international human rights law to health. These are some of the most infamous experiments in the history of the world, and it really didn't take a bioethicist or a lawyer or a judge to say that these experiments, the freezing experiments or the high altitude experiments, both of which resulted in death, were unethical, illegal crimes against humanity. Nonetheless, the judges went further than that and set forth what we know as the Nuremberg Code today, saying that what are the standards going forward. Forget, obviously, what the Nazi doctors did was unconscionable and war crimes and crimes against humanity, but what standards should be followed, like informed consent, in the future. And Professor Mariner has mentioned one of the major documents that also came out of the war, the Universal Declaration of Human Rights in 1948, which included the right to health. And in 1949, the Geneva Conventions, another major international treaty rather than a declaration that came out of the war as well, as did the UN and the various documents that the UN has put out since then. One metaphor that's been used that you can think of that's been used for human rights has been the star metaphor. It's like stars. They're like some people think that like infinite, that there's too many human rights, that we get carried away with human rights. Others that we gets us to look at least in a greater perspective of what health and human rights are. I've suggested back in 1980 in the University of Connecticut Law Review, thinking about health law and what it meant, that we could analogize health law to a red giant star. Astronomers in the crowd, this is maybe carried away by metaphors, but I always get carried away with my metaphors. But I was pleased John Robertson mentioned the future diary this morning. That's my favorite metaphor for DNA molecules. But I suggested in 1980 that health law was like a red giant star, in that it was expanding. What happens with red giants is they're dying stars, but they expand. For the first thing they do is expand, and then after they use all their fuel, they contract to white dwarfs. And that's the way stars go, and I suggested that health law was going the opposite way, from a white dwarf, a little white dwarf, I keep doing that, to a, how did I get rid of that before? I did that, but it doesn't work. Okay. Going the other way. Whoa. That's not right. Let's go backwards. There we go. There. Okay. It was going the opposite direction, from a white dwarf to an orange giant. I think that's definitely happened. I mean, health law just continues to expand, and the reason it does that, I think, and I have no problem with health law being described as an applied field. It is an applied field, as far as I'm concerned. It's a law applied to a giant area of society, and not just 16% of the gross domestic product, but an area of living in life, literally living in life, that is, of course, at the core of our humanity, even used to describe what our humanity is. But star is not quite right anymore. I think the star analogy is not quite right. I'm trying to think of a better metaphor. But this is how I think one can think about the relationship between health law, bioethics, and human rights. And there should be a name for that. There's not a name for that. Biolaw is not the right name. There should be a name for all three of those fields together. But let's talk about what they are. Bioethics, and this has been said, Dr. Groden talked about this before, is primarily based on looking at the doctor-patient relationship, certainly the individual and the professional, and it's aspirational. What should be done? What are the things that should be done in the doctor-patient relationship? What obligations does the profession of medicine have? And what are the goals that medical professionals should aspire to? Okay, and again, some of that was at issue in Nuremberg in the context, the one context of human experimentation, but obviously the informed consent that was articulated at Nuremberg has been applied to treatment as well now, and is at the core of bioethics. Health law, Professor Mariner's already talked about this in detail, but health law is what is law, so it's made by the state. It's not made by individuals, by the state. It's required, and at some level one can argue that therefore it's politics. That's how we make law in this country and other countries, is through politics. It's at the group level, not the individual level, and it's duty-based. It's not aspirational anymore. It's required, as Lon Fuller described it. It's the difference between the morality of aspiration, which is ethics, and the morality of duty, which is law, things that you have to do, not to be an outlaw. And then the other area that Professor Mariner mentioned is human rights, which is global. All right, it's species level. Now we're going far. It applies to everybody, universal human rights. And it's primarily treaty-based. And the treaties are law, international law, which, as we all know, we have a very, very difficult time enforcing. So some people argue, and I'm not among them anymore, it's better to look at this as international ethics. It is globalized, but mostly we use naming and shaming rather than bringing you to the new International Criminal Court to try to enforce human rights. And even though, unfortunately, that's true of torture and genocide and the crimes against humanity, it obviously is even more true when we talk about the international human right to health, the economic, social, and cultural rights, which don't even have a tribunal to bring you to if you don't follow those. and does have the concept of progressive realization based upon your resources. Nonetheless, my question now is, what metaphor would you use to try to think of these three fields? Okay? And the metaphor that has been used, and I've used it myself, is, well, that's the view of the field. How would you put all those things together from contagious diseases, global diseases, crimes against humanity, et cetera? The metaphor that's been used, and again, as I say, I used it in American Bioethics, is a tree metaphor. Everybody uses a tree metaphor, right? The tree metaphor is used for evolution, it's used for life, it's used for the human species. Kant used it for philosophy, and it's used for, and my friend Jonathan Mann used it for health and human rights. And the question is, when you use a tree metaphor, what are the roots, what's the trunk, what are the branches, and what are the fruits? Okay? And you can play this game almost any way you want to. You can use the roots as philosophy, the trunk as international human rights, the Universal Declaration of Human Rights, the branches, the various human rights articulated in the Universal Declaration of Human Rights, and the fruits, some of the fruits being health law, depending on the right that you're looking at, some of the fruits being ethics, depending again on the right that you're looking at, et cetera. And you have this nice tree. And as I said, there's all kinds of trees. This is the tree of contemplative practices. I'm sure Dr. Groden in his Tai Chi classes is very familiar with. And you can use trees for anything, and it's the wrong metaphor. Right? It has recently been recognized in science that the tree is the wrong metaphor for the human species. It's the wrong metaphor for evolution. That's just not the way evolution started, and whether you believe in evolution or not, evolution is much more complicated. In other words, there's all kinds of side tracks, all kinds of mutations, all kinds of interactions that don't follow the tree metaphor at all. And I think it's true of the relationship between bioethics, human rights, and health law. And the better metaphor, I know this is tentative, work in progress, but the metaphor that's been accepted by many in science now is the web of life. I like the term, the web of life, right? That it's a web more than a tree, that it comes together in all kinds of different ways, and that it's unpredictable. I don't know where that came from. I'm sorry, yeah, the globalization, and globalization's got a whole bunch of metaphors too. And I want to just look at those quickly before we decide how we're going to do our web. And I'm going to stop doing that. I'm not going to stop doing that. Okay. And in the globalization, the hottest metaphor in globalization, you'd think it would be the globe, I guess, but it is the rhizome. And the rhizome is any kind of plant. This one is a fern that propagates itself by spreading its roots underground. All right, it's not quite thought of that it's secretive, but it again spreads itself globally, if you will, or anyway, parallel to the surface, and fruits pop up at all different places. It has different nodes that are basically unpredictable. It's non-hierarchical is the main point, and its growth is not determined linearly like a tree is. Okay, I'm not crazy about the metaphor because nobody knows what a rhizome is. You tell them that we're using a rhizome metaphor. What the hell does that mean? But let me tell you, the globalization people love that metaphor. The better metaphor, I really think, is the web. It's a simplistic metaphor. Maybe it's used a lot, right? We hear about webs and nets all the time. The internet, the web of life, as I said before. Nonetheless, it's a good metaphor in that it shows things interconnected, different sizes, different shapes, and to make it a little more sophisticated with the metaphor, we have to add the spider to the metaphor. The spider is the one that makes the web, obviously, but it's not just one spider. We're doing health law, bioethics, and human rights. The right metaphor, I think, is a series of interconnected webs made by 3 spiders, all right? And the webs are overlapping, interspersed, and organic in a sense that they all work together, that human rights is informed by health law. The right to health is informed by what governments actually do and can do in law to make their citizens, bring the capacity for their citizens to lead healthy lives and to deliver decent medical care, decent nutrition, decent education, etc. It's also informed by the medical profession, what physicians can do, the nursing profession, what the professions can do by ethics, in other words. And those things change. The ethics of the profession change. And they affect law, and they affect human rights. And all three, health law, bioethics, and human rights, at least on the global level, work together and are interconnected and define each other. And we even have some remarkable things like medical organizations adopting basic human rights standards. I mean, that could be kind of unheard of. Obviously, it didn't exist before World War II. But for example, the World Medical Association adopting the International Human Rights Standard against torture in the Tokyo Declaration, and adopting very recently at Malta, adopting the International Human Rights Standards against force-feeding hunger strikers as a standard in medical ethics. Right? These could also be adapted, of course, domestically by law, which would be health law, applied to that. So that's how I think it really works in the real world. That these, it's not a tree. Doesn't organically follow. It's much more interrelated contextually. Parts grow up and become prominent in sometimes unpredictable ways. I think Kevin Outerson did a great presentation on the question of a cervical cancer vaccine. We didn't have a cervical cancer vaccine, so that wasn't an issue. Now we have one, but we're not making it available to 97% of the women in the world who need it. That's a new issue. Okay? That just came up from the outside. How are we going to deal with that? I mean, is that a question of bioethics? Is it a question of global justice? Is it a question of international human rights? Do we need a law here in the United States to change patent protection, et cetera, change the way we protect patents globally and TRIPS? Or how are we going to deal with that? That, I say, cannot be handled by any one of these things, but I think it's going to be handled by the overlapping of health law, bioethics, and human rights. Science, a couple of weeks ago, talked about the cosmic web. Webs are all over. Webs are the new metaphor in science, not just in stars, which we started with, but in the tree of life as well. End with just a mention of going global, even in our department, in the Health Law, Bioethics, and Human Rights Department. We also have our own NGO, Global Lawyers and Physicians. And the idea behind that, the theory behind that, I'm sure you got by now, is that lawyers and doctors can do better working together than apart, but that they should work globally, and that being confined to any one jurisdiction, being confined to health law as politics, if you will, is too confining now and too restraining. And we'll end with a final metaphor, which is the shipwreck metaphor, which you hear all the time, especially in the context of U.S. healthcare, which is always said to be a shipwreck. And we've said that every year for the past 30 years. It's a shipwreck. It can't possibly, it's going to drown. We can't possibly continue on. And we do continue on, and we wonder why. And this is the famous painting, Jericho's painting of the raft of the Medusa. Many of you have seen in the Louvre, I'm sure. One of the most famous paintings in the history of art, where he pictures the survivors. This raft had been cut loose from a sinking ship 14 days before he paints this portrait, at which time there were 170 people on this raft. They're up to their neck in water, but they were all on the raft. Now there are 15 live people, 3 dead ones on there, and they've gone through almost every horrible thing that human beings can go through. Mutiny, murder, cannibalism, death, destruction, attacks by sharks, etc. And we have the survivors there. And some of them have simply given up. You can see the gentleman, you barely see the gentleman in the front staring out at you, is despair, totally in despair. Other people are still very hopeful. The gentleman up on top is signaling to what looks like a ship in the horizon, looking for salvation. And again, you find yourself find yourself on this ship. I don't see this as a metaphor of looking for a theory of health law, bioethics, and human rights that we may never find. But Julian Barnes sees it as a metaphor for life, and I think there's some truth to that. He says that we're all lost at sea, signaling frantically for something that may never come to rescue us. Well, I'll leave it at that. Thank you very much. Okay, if we get Wendy back up here, we take a few questions, and then we have a very short wrap-up of a 50-year history of health law at Boston University. Very short.
George, hi. This is a great question. One metaphor you didn't use that has been often used and to more or less effect is the market metaphor. And I'm just curious why you didn't think of the market as a metaphor for healthcare, if you could comment.
I mean, I certainly think of the market metaphor when I talk about health care, but now when I talk about health law, all right? Sure, with health care, I'd say there's two main metaphors, that's what I usually say. The military metaphor, we fight diseases in the front lines, that's exactly right. We're going to conquer them, even if we have to kill the patient's body is the battlefield, et cetera. But, yes, and that's a very dysfunctional metaphor that we use in medicine a lot. And but we don't use the military metaphor the way we should use it, I think, to say that this should be run by the government and financed by the government, that like war is and like the military is, which we totally kick out of the private sector. On the other hand, we use you're right, we use the market metaphor all the time to say that this is we're not patients, we're consumers, that we should have choice, that the market should determine what product lines are available, and we should be treated the most efficient way possible, that the companies involved can maximize their profits. A lot of people from BU know one of our famous professors. We have many here, but Christopher Ricks is certainly one of them. He wrote a terrific book review in a New York Review of Books, I think 2 weeks ago. But it's about something not related to health law at all. But at some point he talks about corporation speech, and then he, just in a little parentheses, says corpse speak. And he meant corpse as a dead body, not corpse as a corporation. And I think that corpse speak is perfect market metaphor for how functional the market is in healthcare.
Great topics. My question is, since we're talking about the future of health law, the technology is moving on daily, if not minute by minute. For example, stem cell research. How do you think health law should evolve to better regulate or better coordinate with the development of those kind of novel technology, which will define the future personalized medicine?
A couple questions there, but let's we do the stem cell one. How health law should regulate stem cell research. I mean, you can see the real dilemma there is whether it should be state-based law, whether it should be jurisdictional law, or whether we need global law. All right? And one of the big problems or challenges of technology is that, and especially things like stem cell research, is if you regulate it in any jurisdiction, let's say our jurisdiction, England, Singapore, Sweden, they talk about jurisdictions that have tried to regulate stem cell research, China, the tendency is for corporations, at least small corporations, not large corporations as well, to jurisdiction shop, to go do their research in the jurisdiction that has the friendliest regulations. So if you really want to regulate it, and it's a good question whether we do, it's got to be international in some way. All right? We're not going to have a treaty. We've actually tried at the UN to have treaties in embryo research, which is part of stem cell research, embryonic stem cell research, and that hasn't succeeded. But ultimately, in a globalized research community, if you want to regulate it, and again, I'm saying maybe we don't, we need some kind of international regulation, even voluntary international regulation, if we want to be effective at it. So far, we don't. So far, in the United States, we have state-based regulation. Feds won't spend any money on embryonic stem cell research outside of the stem cell lines that have already been approved before the president's speech way back in 2001. So each state has its own set of regulations, as Massachusetts does as well. You may or may not think that makes any sense. I think that's just silly. Like whatever, and in this country, whatever regulations we have should be national, and in the rest of the world, whatever regulations we have should ultimately be international. But that's a challenge. We don't have a forum to go to other than the UN to try to do that, and the UN has been unsuccessful.
If I could just add a quick comment. I mean, there may be some opportunity for optimism in some spheres for regulation at the international level, because many corporations would like to see international standards for example, for certain products, for certain pollution controls, simply because they don't want to have to make different products for different countries. Now, stem cells and other problems, I think, are a little bit sui generis because they raise research problems, but that's another reason why I think that it's important to look at some of these in the global context, particularly when you're dealing with product standards, safety standards, and certain regulatory issues, that there's a market for uniformity in some areas.
Yeah, there is. It's wrong to think that it's always corporations versus the rights of consumers or individuals. It's not. Sometimes the agenda is quite concurrent. Right? There are drugs that are good drugs that people really want and need, and we're real happy that they were produced by the drug companies and that we can get access to them at a reasonable price when we can.
Could I make one response to Wendy's question about the market metaphor? Because it occurs to me that part of the reason we may be talking about the conception of health law at the moment is because there has been a little flurry of activity among scholars who were trained in market-oriented approaches. And they may be looking for a particular approach to conceptualize the field of health law under market-based principles, which you see. And they write a lot, and they send around their papers to each other, and there's a whole series of Olin Foundation scholars who are interested in the topic, and that may be part of it, but it raises an interesting question for the future, as scholarship tends to incorporate empirical research, and empirical research tends to require funding, and more legal scholarship is funded. I'm beginning to see reflections of the funding sponsor in the results of the research that's being published. And I think that's a larger question for academics in general, but one that could be particularly influential in a somewhat unbalanced way if you do not see similar kinds of scholarship from perspectives that are not funded to perhaps encourage a particular approach to the world.
Go back to 1980. I don't want to go back to that article. It's a very famous article. No, it's not actually. Nobody cites it. I suggested 4 approaches to health law. One was the law and economics approach, which I take it Wendy was talking about there. The other was the critical legal studies approach, which that used to be a hot thing. I think that's basically dead now, but maybe I'm wrong about that. The third was the bioethics approach, which I think we have integrated into health law. And the fourth was the public health approach, which is really the global approach, which we're working on integrating into health law.